trying to get in on his computer, but he couldn't figure out how to make it work. And then he got this wiggly gray screen. So then there was a question of, well, does he have capabilities on his computer?
Well, now his screen's off, so if he'd start the video again.
Mr. Abel, did you say you can use your phone? Just go ahead and come in on your phone.
I'm on the phone. I'm on the phone already.
I'm going to set this over in order that you appear at the courthouse next time. How's that?
Well, I have the medical condition that I've been dealing with.
All right. Well, if you can't leave your home and come to the courthouse.
I'm in the video right now.
All right. We are on the record in 2024 TR 617. State of Kansas versus Abel Estrada Jr. Please announce appearances.
State of Kansas appears monitor Assistant County Attorney Paul E. Dean.
Richard Paul on behalf of Mr. Estrada, who appears by Zoom at a separate location than counsel.
And how does he wish to proceed today?
Judge, I need to withdraw from this case.
Your Honor, Mr. Estrada filed pro se, I do believe. Well, I know it was pro se filing.
Well, I do notice he's taken a number of filings in his own right without going through counsel. Mr. Estrada, you come back to my recollection, we've met in city court, correct?
Yes.
And now this is that tag and suspended license?
No.
So it's a tag issue, Your Honor.
It's the tag, Your Honor.
All right.
I believe Mr. Paul is requesting to withdraw based upon the essentially sovereign type citizen claim followed by Mr. Abel.
Well,
Mr. Estrada, excuse me.
And also, there's been a total breakdown in communications, Judge. He files his own motions. I cannot represent him.
he's okay. All right, Mr. Estrada, you were appointed an attorney. Apparently at one point you wanted one, or maybe we gave you one and you didn't want one.
No, that's not it.
Excuse me?
I'm sorry, that's not it. He's not, Richard Paul is not seeking my interest, and I put everything in an affidavit. He's not representing me. He's actually judging me before, he's judging me before I even go into court. He's not listening to my paperwork, so he decided he doesn't want to represent me. So I still need to be represented.
Well, Mr. Paul, you're allowed to withdraw.
Thanks.
You're welcome. Is this the last case you have on the docket?
Until 11, Judge. I have an 11, so I'm just going to mute myself and.
That'd be fine. All right. Now, I think you are going to have the same problem with any other attorney that you had with Mr. Paul. Mr. Paul, from this court's experience over the years, is a very competent, diligent attorney. Now, sometimes attorneys have to tell you their opinion of what's going to happen, and you may or may not agree with their opinion, but you do still want an attorney.
I do. I do need an attorney because I don't know how to defend myself with this court, and also I have a thread of the communications that you can see it, and I'm not getting represented correctly. I'm sure he's a competent attorney, but I proceeded to give all my information, all my laws, and he doesn't.
Your what? Your laws?
The laws, the Constitution.
Your Honor,
So,
Your Honor, could I say something, please? Mr. Estrada, every attorney who the court can appoint to represent you, one, I don't want to see, and I'm sure the judge is the same way, I don't want to see any kind of communication thread between yourself and Mr. Paul, because there could be confidential, well, I'm sure there's confidential and privileged information within that, and you shouldn't be disclosing that to me. That's between you and any attorney you so choose to have represent you. But I believe most attorneys, or all attorneys that the court has available to appoint to you, they are sworn to uphold the Constitution of the United States and the state of Kansas, and not what you filed. That's the attorneys didn't go to your law school, which is kind of what you've set forth. So that's the issue the court's talking about when you're claiming a sovereign citizen. We don't have an attorney who's, I guess, registered to under your rules and laws as you see them. So that's the problem you're going to be running into as far as the attorneys the court has to appoint to you. If I said that correctly, Your Honor.
Thank you, Mr. Dean.
I'd like to say that I'm not a sovereign citizen. I'm just an American, and I'm just being constitutional, and I'm not doing anything. I'm not breaking any law. So,
Well, sir, you said the attorney wouldn't accept your laws or follow your laws.
no, that's not what I said. I
Okay,
said that,
what did you say? Because I thought you said you were trying to train him on the laws, in essence.
no, I don't. I'm just presenting the law to
Alright.
him, and he doesn't even read my documents that I presented, which is the law.
Did you go to law school?
No, ma'am.
He did, you know that.
Yes, I understand, but he's not being constitutional. That's what I'm saying.
But you didn't go to law school, so are you sure you know what being constitutional involves? I mean, we all can read the Constitution and understand, yes, but there's a lot involved in interpreting that. Do you understand?
I understand what you're saying, ma'am. All I'm saying is that he's using case law, not constitutional law. And he didn't see all my paperwork. He just ignored it. He just blew through it and then gave me the wrong dates. I presented all the documents and he didn't even look at it and ignored the paperwork.
All right, and let me ask you this. You are wanting a trial on this illegal display of a license plate or failure to display, right?
Well, no, I'd like to first, if possible, we can a motion to dismiss with the street
We're not going to do that today. All right, I am going to one more time appoint you an attorney.
Your Honor, can I make a request to the court on this matter?
Sure.
This case carries a maximum sentence of 30 days. Doesn't even have an eligibility or requirement that he be provided an attorney.
Well,
I'm just.
there's
just saying,
potential jail time.
I would like to have if the court wants. I understand if the court wants to appoint an attorney. Absolutely, don't dispute that. But under the circumstance of the defense that's wanting to be presented, I would ask the court to appoint somebody. I get Mr. McClendon is still available.
That's just what I was thinking. He's here in town.
We set this next hearing, give sufficient time, perhaps 60 days, perhaps longer, and we just have it set for a bench trial. And if he doesn't want to cooperate with that attorney, the state would be asking for the court to proceed to trial, whether or not he can get along with the second one or not.
Well, it seems we're on the same page of thinking, counsel.
Mr. McClendon is in the waiting room.
Mr. McClendon.
I can bring him in.
You in city court the night that Mr. Estrada, the gentleman under Motorola, had the tag violation.
Yes, Judge. He pointed me to his case briefly, and then Mr. Watson and I had a discussion and figured it would be more proper for a district court case.
Will you take the appointment if I give him back to you?
I guess, Judge.
All right. So you two have already met Mr. Estrada, right? The good news was he got it dismissed for you in city court, but the bad news is for you, it's back in district court. All right. So do you agree, Mr. McClendon, that we ought to just set it for bench trial, or maybe, or do you, what do you
It's a
want to
bench
do?
trial, Judge. I'm familiar enough with the case.
Okay. He has filed some pro se motions. Okay, Missy, give me a trial date, please.
We can resolve those motions at trial, Your Honor.
Sure. January 3rd at 11. Does that work?
Yeah, it should be fine. Do you want to do that in person or I guess on Zoom probably?
Well, generally we do them on Zoom. Now, if there's some special reason not to, I would hear the argument, but at this time I'm going to set it for Zoom.
That's fine, Judge.
All right. Thank you, Mr. McClendon. I appreciate your willingness to do that. Mr. Estrada, I will continue, you're not on bond, but I will continue the order that you reappear for bench trial January 3rd at 11. And I trust you have Mr. McClendon's contact information and he has yours from your city appointment?
Yes.
You do? All right, thank you. If there's nothing further, we will be in recess on this matter, and you are excused. State of Kansas versus Matthew Kyle Schrader, Jared Regier for the state. Mr. Schrader, do you appear?
I'm here in pro persona sui juris, appearing specially, not generally, and I reserve all my rights, remedies, and objections.
All right. So I find the defendant does appear personally, and Mr. Regier, his charges and penalties, please.
Your Honor, pursuant to the information filed with the court on June 13th of this year, this is a case that appears to involve two charges. Count 1, failed to register a vehicle and classified non-person misdemeanor. Count 2, no proof of insurance and class B non-person misdemeanor.
And you said these were allegedly committed when? Which date, according to the document?
Your Honor, the charging language in counts 1 and 2 appear to allege occurrence dates on May 21st of this year.
And location within Butler County?
That appears accurate, Your Honor.
Okay. All right, Mr. Schrader, can you still hear me okay?
Yes, I can.
All right, I'm having some issues here, as you can see. In count 1, failure to register a vehicle is an unclassified misdemeanor. It carries its own special penalties of a fine up to $2,500 and a potential sentence of 30 days up to 6 months, although probation is an option and time to pay is an option. And no proof of insurance is a B misdemeanor. That carries a fine of at least $300 up to $1,000 and a possible jail sentence up to 6 months. Now, you do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. Because there is the potential for 6 months jail, you would most likely be appointed an attorney if you qualify for court appointed and cannot afford to pay on your own. On the issue of attorney, do you intend to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself, sir?
I will waive my right and present myself.
All right. Is anyone making you waive your right to an attorney today by any threats or promises?
No.
Or any other reason?
No.
All right. And you do understand, for the record, that you do have the right to hire or apply for court appointed if you cannot afford to hire. Do you understand that?
Yes, I'm aware of that.
All right. I will have the record reflect then that you are knowingly and voluntarily waiving your right to an attorney. You're also exercising your right to represent yourself. I'll have the record reflect that in the docket notes and the journal entry. Now then, let's go through these charges. Count 1, fail to register a vehicle. How do you wish to plead to that? You can plead guilty, and that admits it, and we would proceed to sentencing. You could plead not guilty, denying the charge, and we would set it for trial at a later date. Or the third choice, no contest, means you don't want to admit these charges, but you don't want to admit them, but you don't want to go to trial either. So you'd be pleading no contest. We'd still find you guilty without trial and proceed to sentencing today. Another might be, it's not a plea, but another option might be diversion. The county attorney would offer you diversion if you qualified. You'd have to go online, as I've said several times today to others. You'd have to apply and see if you qualify. They'd send you a response within the next couple of weeks in the U.S. mail. if you agreed to the diversion terms, you would sign the contract and send it back. And if you did everything you were agreeing to, they would dismiss the charge or charges against you, charges if they're both diverted. So, but do you want to divert or apply for diversion? I'm not going to say you'd get it. I don't know your history, and that would come into play. But how do you want to proceed on the issue of diversion or plea?
Okay, so before we get to that, on the record, I've recently served a subpoena to the sheriff's office for records relevant to my defense, and the sheriff's office has filed a motion to quash that subpoena. So today, I'm respectfully asking the court to schedule a motions hearing so that we can resolve the sheriff's office's motion to quash, and that I be allowed the opportunity to pursue negotiations.
All right. You have filed a written motion for subpoena of what documents from the Butler County Sheriff? Of what?
There are many items on there, and
so you don't know what you've asked them to bring to court?
Yeah, I do. I don't have it in front of me, but it's a lot of the typical things like body cam, dash camera footage.
All right. And they have filed a motion or a response to quash at least part of what you requested.
Yeah.
All right. And Destiny, do you have both his motion and the response on the file there in front of you?
I show the subpoena, Your Honor, and then I show the sheriff's office motion to quash.
Okay. All right. Well, we will set those for hearing if necessary, but how do you want to plead on these charges before we get to that?
Well, I feel like it wouldn't be appropriate to plea until I get the evidence and I'm able to be informed enough to make an appropriate plea.
All right. So you're telling me you don't want to plead not guilty today. You don't want to plead anything today. Is that what you're saying?
Right.
Well, you understand this is the hearing when that happens. We enter a plea at first appearance. That determines what happens from there. But if you're refusing to enter a plea, and based on what you've told me, I am going to enter a not guilty plea on your behalf, and we can set this for motions hearing prior to a trial date. So how much time, sir, do you think this motion hearing is going to last? Well, I don't know how much time to reserve on my docket.
Are you asking me?
I'm asking you, sir.
How much time I need?
No, I mean how much time the whole hearing you anticipate will be.
20 to 30 minutes.
All right. Let's be safe. Mr. Regier, have you seen these documents he's referring to?
I have, Your Honor, and what I would tell the court is it would appear that on or about the same time that the written objection to defendant's subpoena, Dulcis Teacup, and motion to quash was filed with the court, an entry of appearance was also filed with the court by Mr. Terrence Hulskamp, the Butler County Counselor.
And Mr. Hulskamp entered on behalf of the sheriff's office, apparently. Did he file the response?
That would appear accurate, Your Honor, based off of the information before the state.
All right, so it sounds like he'll be the one that will be responding to that rather than you, perhaps, just to that limited issue, or do you know?
The written response and motion to quash does appear to be filed by Mr. Hulskamp, Your Honor.
All right, let's set a motion hearing on a Wednesday afternoon. Destiny, what do you have available? Somewhere, I would say maybe an hour at the most. And I know that's a lot on the docket because we have so many other things going on, but.
And you do want it on an afternoon, Your Honor?
Yes, I think so.
We can put it on with the bench trial dockets and still label it as the motion, and we can block off the rest of that day. November.
I'm sorry, I talked over November what?
Nope, you're okay, Your Honor. November 12th at 1:30.
All right, well, that all sounds good. Okay, I'm ordering defendant to reappear for motion hearing on the bench trial docket, November 12th at 1:30. That will be by Zoom. And I trust counsel for the state will, of course, let all of their attorneys know that need to be here. All right, so that's where we are. And then if we decide we need a trial date, I'll set it at that time, Mr. Schrader. Do you understand that?
Yep, sounds good to me.
All right, if there's nothing further, let's.
Your Honor, there are multiple matters still to address.
Go ahead, please.
Your Honor, as given the statements made on the record today, the state is requesting a ruling by the court as to whether or not this motions hearing is being set, requested, and this matter is being set over by the defense.
Speedy trial time does count towards the defense if he is asking for this motion hearing to be set and that it be done before trial. And because he did not enter a plea today, I had to enter one for him. So I will definitely count the time against the defendant.
Thank you, Your Honor. Secondly, this is a defendant who seemingly appears pursuant to the summons, so it would appear that the issue of booking as required by statute, specifically pursuant to KSA 21-2501 section B, is outstanding. The state does have certain special recommendations concerning bond in this case. While the state is not opposed to the court ordering an unrecognizance bond, given that the defendant has seemingly appeared pursuant to a summons, the state, in light of statements made on the record, is requesting a higher bond in this case, at the very least $3,000.
Anything you want to say about your bond, Mr. Schrader, before I declare it?
I object to that since I appeared here as I was supposed to.
All right. At this time, bond is set. You said how much, Mr. Regier, based on that?
$3,000 OR was the state's recommendation, Your Honor.
I will adopt that recommendation. Mr. Schrader, you are ordered to appear at the time given by the officers for booking and processing. Your bond will be set at a $3,000 OR. That means you don't have to put up any money unless you fail to come to court at a later date. But if you fail to come to court, you may be determined to owe $3,000 to the state of Kansas on your bond. So look for the breakout room that says, it'll come up on your screen, invitation to a breakout room, and you'll go in with Deputy in Court Security 2 and set up a date and time. Now, if you fail to follow that order and show up at the date and the time the officer gives you and post a $3,000 OR bond, then I very well may have to issue warrants for you. But right now, because you did appear when you were told, I'm going to make it OR, meaning you don't have to put the money up front. You understand that or have any questions about that, Mr. Schrader?
I think I understand it.
Oh, very well. Look for that invitation on the breakout screen. And Destiny, if you'll put that on there for Mr. Schrader for the officer in Court Security 2.
What time? So it's November 12th?
The motions hearing is November 12th at 1:30, correct?
1:30. Okay.
All right. So please accept that breakout room, Deputy. Are you available for that?
I am.
All right, thank you. So Destin, if you'll just put the two of them in a breakout room.
In this hearing, the central issue was no longer the traffic citation itself, but the breakdown in the attorney-client relationship. The defendant argued that his lawyer failed to consider the constitutional arguments and documents he believed were important, while also rejecting the court's characterization of his filings as sovereign citizen-style claims. The court explained that appointed attorneys are required to represent clients within the framework of established constitutional law and binding legal precedent, even when a client disagrees with that interpretation. After finding that communication between the defendant and his attorney had completely broken down, the judge allowed counsel to withdraw, appointed a new attorney, and scheduled a future bench trial. The hearing illustrates an important legal principle. Defendants have the right to legal representation, but appointed counsel must exercise independent professional judgment and cannot simply advance every legal theory a client requests. Ultimately, the court chose to keep the case moving forward while ensuring the defendant would continue to have legal representation.